All right. Welcome back. Welcome back. It's I'm only 2 minutes late, and as you know, for me that means I'm early. But yeah, we should have a fun one today, I hope. It's one I had no, I hadn't forgotten about it. I just hadn't checked in a while, and I got a reminder yesterday to check, and hey, that gave us some fun. So, Shelly, good to see you. Um, and, and so, yeah, basically, for those of you who don't remember, way back May, probably May, June, we did a video, live stream of an absolutely batshit crazy sovereign citizen suing Team Skeptic. And, you know, until now, that was a one and done for us because that there was nothing else to do. And I tried to do a video the other day, but I was having audio issues. So please let me know you can hear me. Just, I'm going to be paranoid otherwise. But so yeah, basically sometime in 2023, I think, Team Skeptic did a video on this woman covering her appearance in Michigan court. She appeared in front of a lot of judges, so I can't remember exactly which one. I know she's been in front of Judge Oakley, as we saw yesterday from Team Skeptic and various others. So, she's right there in the Detroit area. And several months later, she sued Team Skeptic and YouTube. And I say she sued Team Skeptic, and I literally mean she sued Team Skeptic. Not David Omo, she sued Team Skeptic. And obviously never served him. It was part of a flurry of lawsuits, and it just I don't have confidence in the chat function on this on Restream. So hang on one sec. Just so I have backup. But yeah, so we read through that and her other lawsuits. They were nice and short, and we received word. I somehow I think it was just in one of the other lawsuits. Basically, it said, so everything's consolidated into Duneski versus Shitter, X, Twitter, Shitter, or Facebook or whatever. It was, everything was consolidated into one lawsuit. And so, and then that's where we stood for the longest time. And I had Pacer open with the lawsuit on my old computer, and would check, would refresh it periodically, and nothing. Finally, I get this new computer. I don't even open it on this computer in November. And it was right about when I got the new computer that the update happened. So I was unaware of it until, like I said, Team Skeptic did his first in a 4-part series yesterday covering this Looney Tune again. And I was like, oh, I should check that. And I did. And we have not only do we have an update, we have the update because it's over. Spoiler alert, Team Skeptic won. And so before we get into that, though, now that I've waffled and introduced and given people a time to join, I realize I have been relatively quiet recently, so I'm not expecting YouTube to push this out too terribly much. But now that I've waffled, for those of you who forgot or are new, hi, I'm Joe. I am an attorney licensed in Utah, and this is all in Michigan, and well, at least in the Michigan federal courts, Team Skeptics in Texas. So, and Ace Technical, you're right. Well, some of them. So when they do silly crap like this, it makes me think they really believe the BS they spout. Some of them, I've discussed my sort of overarching theory of sovereign citizens before, and I've mentioned, there are 3 broad camps. There are the grifters. So right now that's like Brandon Joe Williams, Chili DeCastro, Squeak, for those of you who remember the classic video, getting Squeak on the phone. David Straight, Russell Gould, and the other, postmaster, court, general, judge, whatever. Those are the grifters. And, it is a Venn diagram, a 3-part Venn diagram. So some people do belong to all of these. But so you have the grifters trying to sell bullshit to others for money. They know it's bullshit. They know it doesn't work, but they're going to get theirs. Then you have the desperate. And these are the ones where the grifters are just the most insidious, awful, terrible people because they're ruining desperate people's lives. And I hate that. I absolutely hate that. Because what happens with the desperate is they've lost their driver's license. They just got their 3rd driving suspended ticket. Or they're paying child support they can't afford. Or they're, something that they can overcome. It's not going to be easy to overcome, but they can. They just have to work the system. They have to work through the system. Instead, they go to YouTube or Google or whatever, Facebook, and they Google, how do I get my driver's license back? They Google, how do I get out of paying child support? And hey, they actually get good advice on the first couple of results because, you have lawyers paying Google a lot of money to show up first. And saying Google pulled up Google on my phone. But they do that, and it's, you have lawyers paying Google a lot of money to have the first result, even the second. Maybe the entire first page you have lawyers paying. Personal injury attorneys, here you click on that sponsored search result on Google, you just cost that personal injury attorney $600 to $1,000 depending on the market. lawyers pay a lot of money to show up in the search. But they don't like the results, so they keep going until they find an answer that they want to hear because they're desperate. And so they come across on page 7 of Google Brandon Joe Williams, and they're like, sounds too good to be true, but I'm desperate, so I'll try it. And they get in deeper and deeper shit, and Brandon Joe Williams sees no consequences, at least not yet. He makes his money hurting people. And then the third group is the true believers. They truly believe that they're a sovereign citizen, that the laws do not apply to them. And I believe this Lindsay Duneski is a true believer. You look at her in court, she's a true believer. She's got the crazy eyes. She's just, I'm not a psychiatrist, I'm not a psychologist, but I know nuts when I see them. And she's nuts. And I can say she's nuts because that's not a diagnosis. That's an observation. So before we get into the result, now I did post a link in the description, at least on YouTube. I'm also talking to Kick and Twitch right now. So if you're the one Twitch viewer right now, hello, say hi. So I posted the links both to my previous video and to Team Skeptic's 2 videos on her. So the one from yesterday, as well as the one from like a year and a bit ago. So do watch those if you haven't. They're aggravating and hilarious. And as I commented on Team Skeptic's video yesterday, I don't know that I have ever laughed as hard as I did reading her complaint against him and the other complaints. So that being said, before reading the result in the case, do we do a quick dramatic reading of the complaint just as a refresher? It's like 4 pages. I won't do any commentary. It'll just be dramatic reading with me trying not to break. So let me know, do you want that, or do we just jump straight into the new stuff? And Shelly, yeah, she thinks, so Chuck is her ex-husband. All of this stems from the divorce. Chuck has a daughter from a previous relationship. Duneski has not adopted that daughter. She has no legal custodial right to that daughter. Chuck divorced her. That's the end. That's the end. The daughter is not hers. She's trying to assert custody over that daughter, and it's bonkers. It's terrible. It's maddening. And Ace says yes, so we'll do it. But so just as a reminder, so this is not specifically Team that we have pulled up on Pacer right here, Court Listener, the free Pacer, because I'm cheap. This is a search of Lindsay and Duneski on Pacer, just as a refresher of the lawsuits. So we have Duneski versus Nurswick. That is Charles Nurswick, Chuck Nurswick, the ex. And you'll notice in the title, Duneski enjoined filer. So you guys have asked in the past, what does it take to, become a vexatious litigant? What does it take for the court to call you a vexatious litigant? Ms. Duneski found out. She is, at least in the Eastern District of Michigan, she is a vexatious litigant. Now, remember, what was his name? I've got a stream from way back a year and a half ago. It's titled something like, this is what a vexatious litigant looks like. And the dude that basically spent his time in federal prison 15 years ago, entertaining himself by filing lawsuits. And so he's a vexatious litigant in a lot of jurisdictions. And it's good to see you too, Zoe. And so Ms. Duneski, at least in Michigan, is, and you'll see she's an enjoined filer. She cannot, at least without the court's permission, file new lawsuits in Michigan, federal court. So we have, like I said, Duneski versus Nurswick, Duneski versus Duneski. This one's just titled Duneski. It is the Team Skeptic one. We have Duneski versus Fanta, Duneski versus Price, another Duneski, Duneski versus Shitter, Duneski versus Price, versus Facebook, versus Roseville Police Department. On to page 2. If my computer wants to go there any day now. Come on. Okay, so Duneski versus Triplet from all the way back in 2023 now. Duneski versus Brooks Green. Duneski versus FBI. Duneski versus 22nd Circuit Court, Washtenaw County. And then we have a Tribune Media Company, but that's not her. That's a bankruptcy case, and one of the weaknesses of the Pacer search engine is if you just put a name, even if it's a full name, Lindsay Ann Duneski, you're going to get bankruptcy cases, because bankruptcy cases, they have to list all the creditors of the debtors, and you're going to have a whole bunch of names in it. So like for a while, for a while we got the discount store was Tuesday Morning, I think. They had one of the old, I'm talking 90s sitcom women doing commercials for Tuesday Morning. But for a while, you'd search anything on Pacer and sort by newest results first, newest filing first. You got the Tuesday Morning case because, there were a lot of creditors in that bankruptcy. And Church of POS, I disagree. Chile is, in my, triangle of sovereign citizen, she's firmly true believer. Chili is, I don't think he believes it. I think Chili is 100% sovereign citizen grifter. And, as far as, the belief in sovereign citizen. Now, filing a lawsuit over any perceived grievance, sure, she's exactly like Chili in that case. But as far as being a sovereign citizen, I think they're very different flavors of sovereign citizen. So like I said, this is a very short complaint, 5 pages total, and that includes all the spaces. Now, she claims, at least in court, she claims she's studied law, maybe been to law school, something. If I hired a second-year law student and they came to me with this complaint, they wouldn't work for me. That this isn't good. I mean, even just the formatting is jarring, but that's besides the point. So, in the United States District Court for the Eastern District of Michigan, we have Lindsay Ann Duneski, plaintiff, versus Team Skeptic and YouTube, defendants. And it's assigned to Gershwin A. Drain, referral to Kimberly G. Altman, judge. So, claim of harm and trespass, and demand for trial by jury due to violation of constitutional rights. How Team Skeptic violates her constitutional rights is, well, difficult. But, sorry, no commentary. We need to speed through this. If you want commentary, that is on the last video. So, introduction. This is a civil action seeking damages for defamation, intentional infliction of emotional harm, intimidation / tampering with a witness, trespass, harm, and violations of plaintiffs' First, Fourth, and 14th Amendment rights under the U.S. Constitution. Jurisdiction and venue. This court has jurisdiction over this action pursuant to 28 U.S. Code Section 1331 because the claims arise under the Constitution and laws of the United States. Venue is proper in the Eastern District of Michigan under 28 U.S. Code Section 1391B because a substantial part of the events or omissions giving rise to the claims occurred in this district. Parties. Plaintiff Lindsay Ann Duneski is a resident of the Eastern District of Michigan. Defendant Team Skeptic is an individual or entity operating a YouTube channel and conducting business via the internet. I know I promised no commentary, but, well, that's just not good enough. You've got to say where they are. We saw that in the Girlies case, Caffeinated Kitty. Because Caffeinated Kitty has suffered sexual violence, we don't want to put her state on the record. Court said, tough luck, you have to. That's kind of the only decent thing Janet ever did in that lawsuit. Decent as in human decency. But it was still, terrible lawyering. That's like day one, terrible lawyering. Oh, and I'm reminded. So I'm debating whether or not I want to do this. For those of you who see Law and Crime and stuff, you're aware there is a new lawsuit brought against Ruby Franke and Jody Hildebrand, those monsters from here in Utah. And I'm tempted to cover that, but the complaint is like 120 pages. And you guys know me, that would take me like 6 months to get through. But my law school classmate is one of the plaintiff's attorneys in that, so I'm really tempted to. But yeah. So, defendant YouTube is a corporation organized under the laws of the state of Delaware, with its principal place of business in California, and conducts substantial business in the Eastern District of Michigan. Factual allegations. Defendant, Team Skeptic, created and published an erroneous, misleading, and defamatory video on YouTube about plaintiff Lindsay Ann Janeski. This video was intended to torture, harass, and inflict undue emotional, mental, and reputational harm on plaintiff. Defendant Team Skeptic's actions were done with knowledge of the falsity of the statements or with reckless disregard for the truth, causing significant harm to plaintiff's reputation and emotional well-being. Defendant YouTube allowed the publication of this defamatory video and enabled the deletion and censoring of comments that were true and served as a valid defense against the defamation. You look at the video and she has a lot of comments in there. She's like, if any of those were deleted, because she put a lot of them. And Paul, I don't know. I mean, they hold you as a slave? Like, that would violate the 13th Amendment. But yeah, most amendments, individuals can't violate, or at least not without being an agent of the government. Let's see. Okay, we're on 11. YouTube, at the request of Team Skeptic, censored these comments, making them complicit in the defamation and contributing to the harm suffered by plaintiff. Defendant's actions included intentional infliction of emotional harm by making false and derogatory statements intended to cause severe emotional distress to plaintiff. Defendants engaged in intimidation and tampering with a witness by using their platform to threaten, harass, or coerce plaintiff in relation to her involvement in legal proceedings, meaning her criminal case and custody cases. Because, yeah, that's how it works. Defendants' actions have violated plaintiff's First Amendment rights by retaliating against her for exercising her right to free speech. Defendants have violated plaintiff's Fourth Amendment rights by intruding upon her privacy through unlawful means. Lady, no one wants to intrude on your privacy. Like, there's not enough bleach in the world to make me intrude on her privacy. No. No. Ugh. Defendant's actions have also violated plaintiff's 14th Amendment rights by denying her equal protection under the law. Defendants committed trespass by intruding upon plaintiff's physical or virtual property without consent, causing harm. So the live stream of the Washtenaw District Court or Circuit Court or whatever court, that court live stream that she has no proprietary interest in is her property. Okay. So the Dark Connect, Lindsay Ann Duneski, a sovereign citizen, vexatious litigant who sued Team Skeptic, is who her is. And so I did a video actually giving analysis of this complaint back in like June. Just, go back through my list of live streams, and it's the one titled, Team Skeptic sued, or something like that. This is just a dramatic reading as a refresher. But, and then, there are a couple of links in the description of this live stream pointing to Team Skeptic's videos about her, and he has 3 more coming out, and yeah, emotional damage is really, really, really difficult to prove and to collect on, and it's not called emotional damage, it's called intentional infliction of emotional distress, or even rarer, negligent infliction of emotional distress. And as I've said many times in the past, intentional infliction of emotional distress is basically, it's RICO light, lupus light. It's meaning, as Dr. House says, it's never lupus, except for that one time it actually was lupus. In the law, especially civil, it's never RICO, except for that very, very, very rare case that it actually is. Spoiler alert, the new Ruby Frankie Jody Hildebrand lawsuit is a RICO lawsuit, and it might actually be RICO. It might be RICO. It might be lupus. It might be zebras, not horses. So, yeah. So claims for relief. Count 1, defamation. Plaintiff realleges and incorporates by reference each and every allegation set forth in the preceding paragraphs. That's about the only decent thing she's done in this lawsuit. And it really annoys me in legal writing that you have to do that. But defendants made false and defamatory statements about plaintiff. Defendants acted with actual malice or with reckless disregard for the truth. Plaintiff has suffered harm to her reputation and emotional distress as a direct result of these statements. Count 2, intentional infliction of emotional harm. And that might be what it's called in Michigan. I don't know. I'm a Utah lawyer, not a Michigan lawyer. The standard is intentional infliction of emotional distress. This is a common law state tort. So most states, it's not, there isn't a statute for it. It's just common law, comes, from the common law of England. It's old. Although this might have developed after. I don't know. I'm not a legal historian. But plaintiff realleges, blah, blah, blah. Defendant's conduct was extreme and outrageous. Defendants intended to cause or acted with reckless disregard for the likelihood of causing severe emotional distress to plaintiff. Plaintiff has suffered severe emotional distress as a direct result of defendant's conduct. She's just regurgitating the elements of each of these torts. Iqbal and Twombly would be rolling in their graves if they were dead, which I don't know that they are, because those cases are from like 2008, 2009, or 2007, 2008, because, yeah. But either way, of course, these days I have no clue what the law is, because things are nuts right now. Count 3, intimidation / tampering with a witness. Plaintiff realleges, blah, blah, blah. Defendants engaged in conduct intended to threaten, harass, or coerce plaintiff in relation to her involvement in legal proceedings. Plaintiff has suffered harm as a direct result of defendant's conduct. Count 4, violation of First Amendment rights. Plaintiff realleges, blah, blah, blah. Defendants retaliated against plaintiff for exercising her right to free speech. Plaintiff has suffered harm as a direct result of defendant's conduct. Count 5, violation of Fourth Amendment rights. Plaintiff realleges, blah, blah, blah. Defendants intruded upon plaintiff's privacy through unlawful means. Somehow. Plaintiff has suffered harm as a direct result of defendant's conduct. Count 6, violation of 14th Amendment rights. Plaintiff realleges and incorporates by reference each and every allegation set forth in the preceding paragraphs. Defendants denied plaintiff equal protection under the law. Plaintiff has suffered harm as a direct result of plaintiff's conduct. Count 7, trespass. Plaintiff realleges, blah, blah, blah. Defendants intruded upon plaintiff's physical or virtual property without consent. Plaintiff has suffered harm, as a direct result of defendant's conduct. Demand for trial by jury. Plaintiff demands a trial by jury on all issues so triable. Relief requested under law. Wherefore, plaintiff respectfully requests that this court enter judgment in her favor against defendants, Team Skeptic and YouTube, and award the following relief. A, compensatory damages in an amount to be determined at trial. B, punitive damages in an amount to be determined at trial. C, injunctive relief preventing defendants from engaging in further unlawful conduct. So basically, she wants the court to silence Team Skeptic and violate his First Amendment rights, as she complains that he somehow violated hers. I mean, you violated my First Amendment right by deleting my YouTube comments, even though there are tons of YouTube comments still on the video. But you can't say a word against me. Which of those violates the First Amendment? probably not Team Skeptics, but probably not. Frankly, if Chili had helped her with this, it wouldn't be bare bones recitals of the elements under the causes of action here, because Chili at least makes shit up. Like, I hate to say it, but Chili's a better lawyer than this chick. And Donald, good to see you. First visit here. I've seen you elsewhere, obviously. So yeah. Oop. Keep scrolling down. Don't want to scroll down because I don't want to dox her, even though this is a legal document. So she wants injunctive relief, costs and attorney's fees allowed by law, even though she's pro se, and such other and further relief as justice and the law requires. And I'm going to move this into this window real quick, because it's signed Lindsay Ann Duneski, living woman, sui juris, in propria persona, petitioner, and then has her address and telephone number, so we don't want to cover those, which is why I moved it there. But I wanted to show she does sign it, sui juris, living woman, blah, blah, blah. She is a sovereign citizen. So, or at least exhibits the sovereign citizen signs. So, clicking back, she also applied pro se, she applied to proceed in forma pauperis. So meaning, I'm poor as shit. Please don't charge me the filing fees. Let me proceed for free. Which is a double-edged sword, because if the court grants, basically the court says, look, if we're not going to collect the filing fee from you, we're going to check your case first and, see if it's frivolous. We're going to grant and dismiss, as you'll see. So, so that's what we had. And then, like I said, I checked and checked and checked, like periodically. I'm saying like, every couple of weeks. She never served anyone, not even YouTube. She, didn't subpoena YouTube trying to get Team Skeptic's name, even though, it's out there. I know his name. Chili found out his name. It's out there. But she didn't even bother that. So she never served him, never served YouTube, never subpoenaed anything. Just basically, she failed to prosecute the case, which is reason enough to dismiss. But, so we are going to look at the, we had our appetizer. Our main course today is docket entry number 6 from November 20th. So that was a very nice birthday-ish present for me. If only I had seen it when it was posted. But this is an order dismissing the complaint and enjoining plaintiff basically from filing anything else. Like I said, this one just says Duneski. The others, Duneski enjoined. So, Let's click on that and make it big, which I forgot to do on the other one, but that's okay. So this is, frankly, going to be good legal writing for a change because it's from the judge. Meaning it was probably written by a third-year law student. Or a new grad doing a clerkship. Because frankly, most shit like this is written by judicial clerks and then reviewed by the judge and signed, and it becomes their order. Or, if, let's say, she had served Team Skeptic and Team did a motion to dismiss, the judge might have had Team Skeptic's lawyer write the order, file the order, and then the judge puts his stamp of approval on it. That becomes the order. So that's what happens when you're watching Judge Simpson, and Judge Simpson says to one of the attorneys, have you filed a stipulated order? Did you include an order? Whatever. It's basically, did you, in the motion, you told us what you wanted. In the order, you're contemplating getting what you want, and so you'll file a proposed order with your motion often. And but then if it's a contested motion, the winning party, the judge will often say, all right, you give me an order. And so that's what that is. But since this wasn't contested, it wasn't prosecuted, she dropped the ball, she pooped in the pool, and then scurried home. The judge put together the order, and that's okay by me. So, once again, it's in the Eastern District of Michigan, Southern Division, U.S. District Court. Honorable Terrence G. Berg, order dismissing complaint and enjoining plaintiff. So, before the court is a matter initiated by plaintiff Lindsay Ann Duneski, with the filing of a document on May 23, 2024, entitled Claim of Harm and Trespass and Demand for Trial by Jury Due to Violation of Constitutional Rights. And that's being cited as Team Skeptic, case, 24 CV, blah, blah, blah. And normally you'd put Duneski versus, you'd put the plaintiff's name first, but she filed so many cases that to differentiate which Duneski case it is, they just cited Team Skeptic. And Kat, have fun catching up. That's probably the best way to do it, is listen to me at accelerated speed. So, yeah. Ooh. I wouldn't actually know that. I mean, Michigan's funny. Donald, you say Roseville, kind of low rent area. Michigan is weird because, and I say Michigan, but I'm speaking Detroit. You look at real estate listings, which I do all over the country just because I'm weird like that. But to purchase in Michigan, Detroit, is cheap. But rent, while cheap, comparatively, rent is a lot more than mortgage. Now, part of that is, what are property taxes? What's the all-in cost of, the monthly mortgage? Because the mortgage payment includes, like I said, the estimated 1/12 of property tax as part of your monthly mortgage payment, home insurance, blah, blah, blah. So like coming from my perspective here in Salt Lake, you can get a house in Detroit for a tenth of what it would take to get a house in my neighborhood, and rent in Detroit for a third of what it would take to get a house in my neighborhood. So it's just, it's weird. But Salt Lake is weird too. Not just because, Utah, Mormon, all that stuff, but Salt Lake is expensive. Like, it's Looney Tunes pricing, but it's not LA, San Francisco, or Seattle, but maybe Denver. But other than that, you've got to go to a resort city kind of to go above, where it's lots of money. Lots of money. I hate it. So in this pleading, Duneski alleges that defendant Team Skeptic, a YouTube channel, created a misleading and defamatory video about her and published it to YouTube. The video Duneski complains of seemingly contains footage of her behavior before a Michigan state court judge during an arraignment. And yeah, Massachusetts, Looney Tunes pricing. Miami, Miami's weird because you have the ultra, and then there's stuff that even from a Salt Lake perspective, I'm like, looks relatively bargainish. But and then New York, obviously, Manhattan, Brooklyn, all that, those are out the window. Those are, but other than that, you're looking at, seashore or ski resorts. Minnesota is expensive, but like I've got friends in Minneapolis area, so I've looked, and to me, coming from Salt Lake, Minnesota looks, very reasonable. At least purchase price, like I said, all in it might be more, but Minnesota looks very reasonable. Part of that, of course, is Utah, great big state, 13th biggest, but you have a very small footprint that, number one, is private land. Over 50% of the state is federal land, lots of state land. So you have very little, but even less of it is buildable because it's mountains and it's desert and there's no water. Utah's the second driest state in the country behind Nevada, I think. I think Arizona's wetter than Utah. It might be the other way around, and Arizona's the driest and Nevada wetter than Utah. Either way, Utah is the second driest. So basically, you have the Wasatch Front, and then nothing else really supports large populations. I mean, Dante, you know what I'm talking about. Dante's from Utah. I think I know basic area. And you're right. It's, here in Sugar House, at the peak, when things were going crazy, 2021, 22-ish, you couldn't get a house in Sugar House for under $900,000, and that was a fixer. Now it's like, $800-900 is kind of a decent-ish house, but they're not big. We're talking, 2,000 square foot, tiny lot, just nice neighborhood. And it's, but like Northern Utah, I think you're talking like Logan, Dante, expensive too. Not Salt Lake expensive, but Logan's expensive, especially when you consider it's a college town, no jobs, no high paying jobs, and it's that expensive, and that's just wild. But yeah. So Janeski asserts the video was intended to torture and harass her and inflict undue emotional, mental, and reputational harm upon her. Janeski further claims that defendant YouTube censored comments on the video at the request of Team Skeptic, making the video sharing platform complicit in the defamation and additionally liable for her harm. Yeah, Meatball, that's a good question. Yeah. Yeah. I'm sure, assuming she saw it, assuming she's even seen it yet, she's probably apoplectic. But good luck suing. I mean, I guess she technically could in state court or in Texas or wherever, but you know, funny enough, I never got threatened by her. Of course, I don't think I saw her in the comments of my video, so maybe she didn't see it. But yeah. So, and Pat's Cat says Nevada, Arizona, Utah, New Mexico, and Wyoming. I assume that's the order. Which, like I said, I thought Utah was number 2, although it obviously fluctuates. You know, we had a couple of really wet winters because everything comes in the winter in the form of snow in the mountains. We absolutely depend on snow. This year has been a terrible snow year, which, you know, Alta's still seeing 250 inches, which is a lot of snow, but it's not nearly enough. We need more. We need more. Pray to the snow gods for us. Duneski claims the relief she is entitled to by law includes the following: compensatory damages, an injunction, punitive damages, and attorney's fees. Duneski seeks to proceed in forma pauperis. This borderline... Oh! Ow! Ow! Of course, I say that, but I'd take out the borderline. I think this was the court being nice. But the borderline irrational complaint, when a court says borderline irrational, they mean this batshit crazy word salad of nonsense complaint, is not the first such matter that Duneski has filed with this court. In September 2021, Duneski filed a pleading captioned "Initiating Motion and Declaration to Void All Judgments, Orders, Debts, etc. in case 21MC blah, blah, blah." So 21MC, that would be a Michigan civil case from 2021. I'm assuming, you know. But number one, you don't file an initiating motion. You file a complaint. But declaration to void all judgments, orders, debts. It's like Michael Scott, I declare bankruptcy. And all your debts disappear. You're washed clean. You don't owe anything. That's I mean, technically, this is a collateral attack using the federal court to attack the judgments from the state court. Collateral attack. You appeal. You don't file a lawsuit to overturn the judgment in the state court. But even if there were a cause of action to say, hey, federal court, declare that judgment void. You don't get to just say, I declare in federal court this state judgment is void. That's sovereign citizen, wibbly wobbly, legal wiggle bullshit. It's utter and complete nonsense. It is fanciful. It is deranged. It is not borderline irrational. It is knucking futz. It's batshit. It is wano. It is Looney Tunes. It's not just Looney Tunes. It's the looniest tune. It's like, it is the Pepe Le Pew stinker of court actions. It stinks. It's Looney Tunes. It does not exist. It does not happen. And just as Pepe Le Pew never gets the cat, you'll never get what you want in court by declaring this nonsense. Because that's all it is nonsense. So that miscellaneous matter was later renumbered as case 23, blah, 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 and the case was dismissed on February 20th, 2024, after Duneski failed to respond to a show cause order. See Duneski versus Duneski, case number 23 CV, so a federal civil court case from 2023. Since that original miscellaneous matter in 2021, Duneski has filed numerous other similarly bizarre pleadings in this court, several of which have been dismissed. For the following reasons, Duneski's motion to proceed in forma pauperis, IFP, in this case is granted. Duneski's action is dismissed with prejudice, and Duneski is enjoined from filing any other actions in the Eastern District of Michigan without first seeking and obtaining leave of court as provided in this opinion and order. So I mentioned at, not at the start, but after reading the complaint, I mentioned going through the docket that this would be how it proceeds. When someone applies for in forma pauperis, IFP, if it's bonkers, the court will grant and then dismiss with prejudice and say, you're gone. No more wasting court's time. You get one chance to waste the court's time for free, and then you're booted. If you don't want to be insta-yeeted, pay the $402 or whatever it is right now. It's been a while since I've looked what federal filing fees are, but you know, if she had paid the $402 instead of being cheap, she at least would have had to either wait for Team Skeptic and YouTube to file their motions to dismiss, or, the courts do periodically go through the docket. As in, they'll go through their roster of cases in the court and say, this hasn't been prosecuted. Has it been long enough to dismiss for lack of prosecution? Yes, no. And in those cases, they'll generally do a show cause hearing. And, there's a certain YouTuber who has a show cause hearing tomorrow. And, what's a show cause hearing? A show cause hearing is where the court basically says, hey, moron, tell me why I shouldn't do this. So in this, if she had paid and just hadn't served anyone, hadn't prosecuted the case, the court would basically be saying, hey, moron, tell me, the judge, why I shouldn't dismiss this case for lack of prosecution. In tomorrow's show cause hearing, it's, hey, moron, tell me why I shouldn't throw your ass in jail for leaving the state. So that's what a show cause hearing is. Yeah. So, initial review of the complaint. This should be fun. I mean, the introduction was fun. This should be fun because the court recognizes that this is batshit. They call it seemingly bizarre. The court recognizes it's batshit. So, a complaint is considered filed only when, and this is in forma pauperis. So, a court is considered filed only when IFP status is granted or the appropriate filing fee is paid. That's Truitt versus County of Wayne, 6th Circuit, 1998. Duneski represents in her application that she has no income or assets and that she is a recipient of SNAP, EBT, and Medicaid. Considering these facts, the court will allow her to proceed IFP. Once an IFP complaint has been filed, the court must review it to ensure it is not frivolous or malicious. Plausibly states a claim for relief. So it's got to survive the Twombly and Iqbal standard of a Rule 12B motion. So it can't be, it has to state a plausible claim for relief. Basically that, because 12B6, motion to dismiss for failure to state a claim upon which relief can be granted. And Twombly and Iqbal set the standards. You need, under Rule 8A of the Federal Rules of Civil Procedure, you need three things. You need a short and plain statement of the court's jurisdiction. So, hey, court, you can hear this case because it is a diversity case. It is a federal question. It is a constitutional question. It is blah, blah, blah. So you need one, short and plain statement of jurisdiction. Number two, under Rule 8A, you need a short and plain statement of the facts entitling you to relief. And as Twombly and Iqbal say, those cannot be a mere recital of the elements of the cause of action, which is all that she put in her complaint. And then third, you have to have your prayer for relief. So I mean, she kind of did 1 and 3. Boy, she took a big turd instead of number 2. Wait, how does that work? Number 2 was a turd instead of 8A2. Something like that. But once again, the first part, the jurisdiction, it's like, well, she's not really claiming diversity jurisdiction. So whether she names Team Skeptic state or not is maybe irrelevant. Of course, she didn't mention that she's got claims there under the supplemental jurisdiction, because that's how you get the state law tort claims in as basically a supplement to the federal question claims. But she didn't mention that, which she should have. So, like I say, her entire complaint's terrible. But either way. So once an IFP complaint has been filed, the court must review to ensure it's not frivolous or malicious, plausibly states a claim for relief, and does not seek monetary relief against defendants immune from such relief. That's 28 U.S. Code Section 1915E2 is the IFP law. So basically, if you want to sue someone IFP, even if you state a plausible claim for relief, if someone's immune, you can't sue someone that has sovereign immunity. You can't sue the state of Utah IFP. It's instigated because the state of Utah has sovereign immunity. I don't actually know. I'm having a brain fart of what it's called, because I'm human and that's what I do. But so I'm not even going to talk about what I'm thinking about. Just going to move on. The complaints of litigants without lawyers are construed liberally. And that's Haynes versus Kerner, Supreme Court, 1972. Even so, all litigants must comply with Rule 8A, which requires a complaint to contain a short and plain statement of the claim showing the pleader is entitled to relief and a demand for the relief sought. So that's 8A2 and 8A3. They didn't mention the 8A1 jurisdictional statement, but who cares? I mean, I clearly do, but... And hey, look, if I had just looked at the next line, they've got the citation, FRCP 8A2 and 3, but no mention of 1. So Rule 8 does not require detailed factual allegation, but it demands more than an unadorned, the defendant unlawfully harmed me accusation. That's Iqbal and Twombly, 2007 and 2009. So, hey, I said 2008, 2009, or 2007, 2008. Just split the difference. 2007 and 2009. I was right on the years. Ish. Background. Duneski states that Team Skeptic's malicious prosecution hinders her ability to acquire income. Duneski notes that filing court documents takes up almost all of her time. Duneski's latter assertion is evident from the record. I'm almost thinking this wasn't the entire. Because these bits weren't in what we just read. So I'd have to compare, except then I'd have to listen to myself and, but yeah, it's almost like what we read was missing some stuff, because I do remember it being funnier. I mean, that was still pretty funny, but it didn't have me rolling on the floor like the last time. So Duneski's latter assertion is evident from the record. She is, meaning that takes up all of her time. It's like, yeah, when you're a vexatious litigant suing everybody that looks at you, not just looks at you funny, but everybody that looks at you, it's going to take a lot of time. So, yeah. She has filed a plethora of unmeritorious suits in the Eastern District of Michigan, wasting the court's limited time and resources. District courts are obligated to protect themselves from vexatious litigants. That's Flint versus Whalen from the Western District of Kentucky in 2011, citing In re McDonald and blah, blah, blah. So courts may impose sanctions to curb vexatious litigation in instances where the claims are meritless. The litigant knows or should know that the claims are meritless and the claims are filed for an improper purpose. One possible sanction, an injunctive order preventing the prolific litigant from filing any additional harassing or vexatious pleadings. See Philippus versus Lemons, 6th Circuit, 1987. In Clemens versus DeWine, I'm assuming that's Ohio Governor Mike DeWine as the defendant, the 6th Circuit set forth a list of requirements that must be met to allow a district court's entry of such a vexatious litigant order. That's 6th Circuit from 2019. Under Clemens, the court must 1. Provide notice to the plaintiff, 2. Create an adequate record for review, including a listing of all the cases and motions that led the district court to conclude that a vexatious litigant order was needed. 3. Make substantive findings as to the frivolous or harassing nature of the litigant's actions. And 4. Narrowly tailor the order to closely fit the specific vice encountered. And basically, notice, hey, she's been served this order. That is notice. And adequate record for review, hey, this is a 16-page court order. A record of the court's review. Substantive findings, 16 pages of findings. And narrowly tailored. She cannot file in the Eastern District of Michigan federal courts without permission from that court. That's narrowly tailored. She can file in state court until they tell her not to. She can file in other federal courts until they tell her not to. She can file in Eastern District of Michigan with permission. That's narrowly tailored. And now we're going to hear the court explain all those elements like I just did. Regarding the first of these elements, the court placed Duneski on notice in January of 2024. it noted that her filing behavior, if continued, would result in the court finding that she is a vexatious litigator. So basically, the court put her on notice that she was facing this sanction even before she sued Team Skeptic. It's just, it's wild. Absolutely wild that the court says, look, you are at risk of being labeled a vexatious litigant. Get your act together. Cut it out. And yet she still filed multiple vexatious lawsuits after she was put on notice that she was facing the sanction. She sued Team Skeptic, Shitter, Facebook, YouTube. She just can't help herself. You know, since she's in Detroit, you know, Motown, sugar pie, honey bun, just can't help myself. I sue you and everyone else. I'm actually kind of happy with that. The Four Tops are probably the best Motown group. Fight me on that. But so in that, the court said, plaintiff is advised that any additional filing of vexatious or frivolous materials in this district will result in her being enjoined and restrained from filing any new complaints in the U.S. District Court for the Eastern District of Michigan against any defendant without first seeking and obtaining leave of the court. And that's from the Duneski versus Duneski lawsuit. And that was filed in 2023, the lawsuit. The order was in January of 2024. In that same order, the court described two other of Duneski's cases that were dismissed. Duneski versus Triplet and Duneski versus 22nd Circuit Court of Washtenaw County. Nevertheless, Duneski has continued to file arguably frivolous complaints and motions. See Sultana versus German, Eastern District of Michigan, 2020, where the court enjoined similarly vexatious litigant. What was that? Not for today, of course. But if this is good, we better document it right now. Right now, because otherwise I'll forget. But if I have a tab open with it and go back and look at it, and I say, oh, this shit is gold, then we've got it ready and we can do another, laugh session. So, yeah. Thank you, court. That was very kind of you to give me potential content. I appreciate it. So, as to the second element of Clemens, over the last year, so create a record, Duneski has filed at minimum 13 lawsuits for consideration by courts in the Eastern District of Michigan. Duneski versus Duneski, Duneski versus Triplet, Duneski versus 22nd Circuit Court of Washtenaw County, Duneski versus FBI, Duneski versus Brooks Green, In Ray, Lindsay, and Duneski. Curious about that one. Duneski versus Roseville Police Department, Duneski versus Facebook, Duneski versus Shitter, Duneski versus Team Skeptic, Duneski versus Fanta, Duneski versus Price, and Duneski versus Nursewick. Duneski's litany of complaints and suits share a common nucleus, stemming from allegations of parental kidnapping of a kid that isn't even hers, of her minor children by their fathers, and Duneski's discontent with the governmental systems, private entities, and individuals unwilling to bend to her wishes, comply with her various demands, nor change course following threats of retribution. For example, in Duneski versus Triplet, Duneski sought an injunction prohibiting defendants from violating her rights and to locate and return her parentally kidnapped children, all arising out of a Wayne County Circuit Court action. Defendants included 1. Judge Regina Triplet of the Third Circuit Court of Michigan. 2. Judge Melissa A. Cox of the Third Circuit Court of Michigan. 3. Andrew Fanta, an attorney. And 4. Charles P. Nursewick, her ex-husband. So remember, one of the elements, mark where we were basically, for informa pauperis. Okay, there it is. Once an informa pauperis complaint has been filed, the court must review it to ensure it's not frivolous or malicious, plausibly states a claim for relief, and does not seek monetary relief against defendants immune from such relief. Get back to where we were. Judge Regina Triplet is immune from cases seeking monetary relief for her actions as a judge, as is Judge Melissa A. Cox. Judicial immunity is almost absolute. You literally have to be committing crimes as a judge to not be immune. That, like, there might be small exceptions to that, but that's pretty much the only thing I can think of. Like the judge that was literally selling children to private prisons for kickbacks. That's how extreme it has to be for judges to be subject to monetary damages. And even then, that county in Pennsylvania probably still paid the damages for that judge. It's just... So, in that case, Duneski's cause of action generally challenges the actions of the defendants with respect to a child custody case. And don't need to review the docket stuff. So on August 9th, 2023, Judge Gray dismissed with prejudice Duneski's complaint and found the action to be frivolous under 28 U.S.C. section 1915 E2B. That's once again Triplet, where Duneski versus Triplet, which held that any appeal of this order would be frivolous and would not be taken in good faith. So basically, you've got to ask to appeal, and we're not going to grant permission because you've been deemed frivolous. This is frivolous. You can't even appeal because you're vexatious. Ouch. Unsatisfied with the dismissal, Duneski filed an objection, a review of which revealed that she, in essence, sought a reconsideration of the court's ruling. After considering the latter filing under both Rule 59E and Rule 60B, let's review, since it's been a while since we've looked at the federal rules of civil procedure. Those are motions for reconsideration, but Rule 59 is a motion for a new trial or altering or amending a judgment, and Rule 60 is relief from a judgment or order, and grounds for relief from final judgment: mistake, inadvertence, or surprise, or excusable neglect. None of those apply. Newly discovered evidence, like newly discovered evidence that it's some other Lindsay Ann Duneski that filed all those frivolous lawsuits. Fraud. Well, the court didn't commit fraud. The judgment is void. Well, there's literally a law allowing the courts to declare people vexatious litigants, so that's not void. The judgment has been satisfied, released, or discharged. That's impossible here, or any other reason that justifies relief. So you'd have to be really, really, really creative to find another reason that justifies relief. And if she does that, she may as well just go to Hollywood and write movies, because, she'd have to be that creative. She'd have to be that talented at getting people to suspend disbelief. Because, Spielberg should hire her if she's able to come up with a reason. So, on September 15th, 2023, Judge Gray denied the objection and again deemed the action frivolous under Section 1915, warning Duneski once more that any appeal of the order would be frivolous and would not be taken in good faith. So at this point, she hasn't been deemed a vexatious litigant. It's just Triplet has been deemed a frivolous case. So she's not vexatious yet. She's just filed a frivolous case. So you have to file multiple frivolous cases, generally, to be deemed vexatious in that jurisdiction. So, but she's been warned. Look, we have found this case to be frivolous multiple times now. If you keep going, we're going to extend it to all cases unless proved otherwise. So, and Mark, it's perfectly fine being late unless you don't want the baby. Then it's, but yeah, I'm glad that Team Skeptic posted his video yesterday, because that reminded me to check this out, and I'm glad, because it's been fun. So, undeterred by Judge Gray's warning, on the 12th of December, Duneski filed additional documents in the matter, repeating her prior grievances and alleged right to relief. Concurrently, on July 24th, 2023, Duneski brought suit against the 22nd Circuit Court, Washtenaw County, Judge O'Brien, Charles Nurswick, and Andrew Fanta. Judge Lightman dismissed the action based on Duneski's failure to present the clerk's office with documents necessary to effect service. Earlier that same week, on July 21st, 2023, Duneski filed suit against the FBI and several of the Bureau's Detroit field office agents for, on May 6th, 2023, acting on a false allegation using a void and fully vacated fraudulent court order to unlawfully seize her children without any just cause, and which is tantamount to kidnapping. I have a feeling that Team Skeptic's second or third video on the subject is going to discuss that, because like we've had teasers from Chuck Nurswick about, like having to tase her as she's holding their autistic child. So that should be fun. Obviously, be on the lookout for Team Skeptic's videos. This is one of the reasons I haven't been active. Someone thought that the plague would be a good Christmas gift, and like I haven't felt sick. I just haven't felt I could do a multi-hour dramatic reading without tearing my voice apart, and I'm starting to feel it, but will persist, just like Duneski. There, Duneski asserted entitlement to compensatory and punitive damages pursuant to USC sections 1983 and 1986. That would be 42 USC 1983 and 1986, and sought criminal charges to be brought against all involved offenders pursuant to 18 USC 241 and 242. So she's asking in a civil complaint for criminal charges to be brought. That's not how that works. That's not how any of this works. In the FBI case, on February 5th, 2024, Judge Boehm ordered Duneski to file an amended IFP application. The original application contained several deficiencies. Duneski listed her minor children's full names, failed to provide a supplemental explanation to a particular question, as explicitly required, and did not include her signature. Duneski failed to correct the application by the court's March deadline, resulting in a directive to pay the $405 filing fee by April 5th, 2024. Damn it, I said $402 filing fee. It's $405. Judge Boehm further warned Duneski that failure to pay the filing fee by the deadline might result in dismissal of the complaint. After Duneski took no action on April 17th, 2024, Judge Boehm dismissed the case against the FBI according to Federal Rule of Civil Procedure 41B for failure to prosecute. And I've never actually dealt with 41B, but dismissal of actions, involuntary dismissal. If the plaintiff fails to prosecute or comply with these rules or a court order, a defendant may move to dismiss the action or any claim against it. Unless the dismissal order states otherwise, a dismissal under this subdivision B, and any dismissal not under this rule, except one for lack of jurisdiction, improper venue, or failure to join a party under Rule 19, operates as an adjudication on the merits. Oh, so It's an adjudication on the merits. She lost on the merits. So the court has reached a result on the merits that ends the case completely. It's over. It's done. You can appeal. You've got a final judgment. That's basically what it is. If it's on the merits, it's a final judgment. Ooh. I've never been involved in something where there's a failure to prosecute. She's an expert at failure to prosecute. Like, I knew you can get things dismissed for failure to prosecute. I didn't know it was 42B or that would happen because I've never dealt with it. On August 7th, 2023, 2 days before Judge Gray dismissed the triplet case, Duneski filed suit against Judge Tina Brooks Green and court administrator Mariah Loves for a slew of alleged constitutional violations involving her experiences with the 34th District Court in Romulus, Michigan. Among them, her arrest for failure to appear, which Duneski claims led her children to be unlawfully removed from her and illegally withheld from her since that time. And Judge Brooks Green might be the one that the Team Skeptic video is from. I'm not positive. So, on October 6th, 2023, Judge Mickelson summarily dismissed Duneski's complaint, concluding both parties were immune from suit. Judicial immunity. Such dismissals notwithstanding, on April 17th, 2024, Duneski filed yet another action challenging the state court proceedings held before Judge Triplett, which resulted in the custody of her children being awarded to Charles Nurswick. Duneski claims an unlawful seizure and kidnapping of herself and her children by the FBI, that Judge Triplett ordered the children injected with an experimental medical treatment against Duneski's will, and that Nurswick and his attorney, Andrew Fanta, presented fraud upon the court. Attorney Fanta is protected by the litigant privilege. Attorneys are generally immune from suit by opponents. If we're engaged in litigation, you can't sue us for engaging in that litigation, generally. Because otherwise, we can't engage in litigation. The court system breaks down. No one gets representation if, I'm not going to represent anyone else if I'm on the hook for representing them. That's not how it works. The system would fall apart. It says, Nurswick and his attorney, Andrew Fanta, presented fraud upon the court. Like the other cases, this action was summarily dismissed, this time under 28 U.S.C. Section 1915E2B. And again, on May 18th, 2024, Duneski filed another case. This one was assigned to Judge Murphy and was dismissed on May 23rd, 5 whole days. This was the Duneski versus Roseville Police Department case. Judge Murphy explained in his order of dismissal, plaintiff's complaint lists numerous constitutional and statutory violations without any factual allegations whatsoever. It appears that plaintiff used a form to fill out her complaint, but failed to add details regarding her allegations. Plaintiff did not allege a date on which the alleged actions took place and did not specify what those actions were or which defendants allegedly took them. Instead, plaintiff's complaint simply lists the definitions of various constitutional and statutory violations without factual allegations. The court will, therefore, dismiss the complaint for failure to state a claim under Rule 8A. So, what's that I hear? What's that I hear? Let's go up. Oh, well, I guess here they didn't quote the part of Twombly or Iqbal I wanted. Bad court. But, Rule 8 does not require detailed factual allegations, but it demands more than an unadorned, the defendant unlawfully harmed me accusation. I was looking for, it needs more than a bare bones recital of the elements of a cause of action. So, bare bones recital of the elements of a cause of action. That's what this was. Simply lists the definitions of various violations. And did you start law school, Grey Duck? If so, if not, why the hell are you reading contracts? I mean, contracts is an okay class. Wasn't the most exciting, wasn't the most boring. So discussion. Earlier this year, Duneski filed 6 more lawsuits in the same general vein. Duneski's latest batch of frivolous complaints were filed between Tuesday, May 21st and Thursday, May 23rd of 2024. So 6 lawsuits in 3 days. Oof. And those were Duneski versus Fanta, so against her ex-husband's attorney, Duneski versus Price, Duneski versus Nursewick, Duneski versus Facebook, Duneski versus Shitter, and Duneski versus Team Skeptic. Duneski's complaints in Fanta, Nursewick, and Price follow a template nearly identical to the previously discussed pleadings. The few areas where the complaints diverge are inconsequential. For instance, Duneski accuses Fanta and Price of fraudulent acts, such as intentionally telling lies to law enforcement, judges, etc., and Nursewick of domestic violence, attempting to run her over with an oversized pickup truck, as well as interference with legal processes and emotional manipulation. Each contains the same primary allegation: deprivation of parental-child consortium. Judge Mickelson dismissed Duneski's complaint in Fanta without prejudice for lack of subject matter jurisdiction. Likewise, Duneski's Facebook and Shitter complaints include numerous constitutional and statutory violations, yet lack factual allegations beyond generalized accusations of illicit collusion between the social media platforms and the FBI. I mean, they do, provide information to the FBI, but illegal or illicit collusion? Prove it. Among such accusations, denying Duneski the ability to effectively share information and communicate her side of the story, discriminating against Duneski based on religious and philosophical views, and unlawfully surveilling, cyberbullying, and torturing her. Facebook and shit. I mean, sure, shitter is torture, but not unlawful torture. It's like it's voluntary. I can turn off shitter. Having carefully reviewed the complaint before the court in this case, it is clear that the claims cannot meet the requirement under 28 USC section 1915 E2, the IFP standard, that it raises non-frivolous claims, and further does not meet Rule 8A's requirement that it show the pleader is entitled to relief. The complaint, therefore, will be dismissed with prejudice. Team Skeptic has won without lifting a finger. I mean, he was never served, so he didn't have to lift a finger, but he has now officially won. It is over. Team Skeptic won. Throw the confetti, hold a parade, raise a glass. I mean, I know Team Skeptic was shaking in his boots, terrified of this lawsuit, as is evident by his making 4 videos about it, only one of which has been released so far. Like I said, watch it. It's linked in the description of this YouTube live stream. And JT Davis, yeah, it's nuts. This is batshit crazy. So Duneski fails to state a claim as required under Rule 8A. Moreover, the action is frivolous, lacking an arguable basis either in law or in fact. Frankly, she lacks a basis in law and she lacks a basis in fact. She lacks both. True. So if you are going to raise a glass of whiskey for Team Skeptic. I'm just raising a, insulated thermos of water because I don't drink. And that's Knightsky versus Williams, Supreme Court, 1989. And thus, Duneski's case falls within the requirements for dismissal under 1915 E2. That's citing McGore versus Wrigglesworth, 6th Circuit, 1997, which was overruled on other grounds by Jones versus Bach. Exactly. He hurt my fifis. I need money now. Gimme. I demand money. So, further, it is apparent that, notwithstanding repeated explanations, warnings, and dismissals by this court, other courts in this district, and multiple state courts, Duneski has demonstrated an intent to continue filing frivolous actions, challenging the custodianship of her children, and seeking to harass those entities and individuals she considers complacent, responsible, or even in any way critical of her behavior. Duneski continues to seek relief where none exists. Oof. So I'm curious. I've never looked her up on the Michigan court websites, but says she's had these repeated explanations, warnings, and dismissals in multiple state courts. So when I say she can't sue anyone else in the Eastern District of Michigan without permission of the court, but that she can potentially sue in state court or in a different federal court. She could sue Team in Texas, although res judicata, this has been decided on the merits. So she has no cause of action against him, at least not based on his first video. I mean, in theory, he's made a new video, new harm suffered. I mean, there's no harm, but, new alleged wrongdoings. So it's possible I was wrong. It's possible she has received these warnings in multiple state courts in the state of Michigan. She might be a vexatious litigant in Michigan state courts. I don't know. I'm not going to look it up. If you do, let me know. But it's possible. So the various judicial officers of the Eastern District of Michigan who have been required to review these complaints have been tolerant and patient in dealing with Duneski's pro se filings. However, there comes a point when we can no longer allow plaintiff to misuse the judicial system. That's Viola versus Yost, Southern District of Ohio, 2022, affirmed by the 6th Circuit in 2023. And Lapine versus Colleran, Eastern District of Michigan, 2021, where Judge Levy said, "We see nothing wrong with an order that places limits on a reasonably defined category of litigation because of a recognized pattern of repetitive, frivolous, or vexatious cases. Every paper filed with the clerk of court, no matter how repetitive or frivolous, requires some portion of the court's limited resources. A part of the court's responsibility is to see that these resources are allocated in a way that promotes the interest of justice." See Miller versus Mount Eaton Police Department, Northern District of Ohio, 2022, quoting in Ray McDonald, a Supreme Court case from '89. Following a thorough review of Duneski's allegations in this case and her conduct in this and other cases filed in the Eastern District of Michigan, the court finds that some restrictions are warranted to prevent Duneski's ongoing abuse of the process of this court. Consequently, Lindsay Ann Duneski is permanently enjoined. Not a temporary restraining order. She is permanently enjoined from filing any new lawsuits or other documents without first seeking and obtaining leave of court. That is written permission from the chief judge or miscellaneous duty judge by following the requirements set out below. If Duneski wishes to file a complaint or any document in this court, she must first file a motion pursuant to court order requiring plaintiff to obtain leave to file, and must attach to this motion a copy of the document she proposes to file, and B, a copy of this order that we have been reading tonight. Such a motion will be filed as a miscellaneous case. In support of this above motion, Duneski must attach the following 3 exhibits. A written declaration which has been prepared pursuant to 28 U.S.C. Section 1746, or is a sworn affidavit certifying that 1. The proposed filing raises a new issue which has never been previously raised by her in this or any other court. 2. The claim or issue is not frivolous. And 3. The proposed filing is not being filed in bad faith. B. a document containing a list showing 1. The complete caption of every suit that has been previously filed by her or on her behalf in any court against each defendant in any new suit she wishes to file, and 3. The complete caption of every suit which she has currently pending, and C. A complete set of copies of each complaint identified and listed in the document required by subparagraph B above, along with a certified record of its disposition. The court may deny any motion for leave to file if it does not comply with the above requirements, or if the proposed filing is frivolous, vexatious, or harassing. If the motion is denied, the proposed filing shall not be accepted for filing. Further, Juneski's failure in any way to comply fully with the terms of this order shall be sufficient grounds to deny any motion for leave to file. Further, to prevent future harassment by Juneski and the waste of the court's limited resources, the clerk's office is ordered as followed. Thank you, Hodgepodge Harmony. The clerk's office is ordered as follows. Any document submitted by Juneski shall not be accepted for filing unless it is a motion pursuant to court order requiring plaintiff to obtain leave to file, which complies with all the requirements of this order. 2. The clerk's office shall not accept any filing fees, cover sheets, IFP applications, summonses, or U.S. Marshal forms in connection with any motion pursuant to court order requiring plaintiff to obtain leave to file, which Juneski files unless and until leave has been granted. Conclusion. And thank goodness it's the conclusion, because I am hungry. Juneski's claims against defendants Team Skeptic and YouTube are dismissed for the foregoing reasons. Accordingly, Juneski's motion to proceed IFP is granted, and her complaint is dismissed with prejudice. Under 28 U.S.C. Section 1915A3, the court certifies that an appeal from this decision could not be taken in good faith. So, no appeal. Over. This is the end. You are done. Good day, sir. Goodbye. And when I say good day, sir, I'm thinking Willy Wonka, not misgendering Miss Juneski. Furthermore, Juneski is enjoined from filing any more actions in the Eastern District of Michigan without first seeking and obtaining leave of court as provided in this opinion and order. So ordered. Dated November 20th, 2024. Signed, Terrence G. Berg, United States District Judge. And that's the end of it. That was an ordeal. A fun ordeal, but still an ordeal. So, the moral of the story, don't be a vexatious litigant. Don't be a sovereign citizen. Be a good boy or girl, and, just don't be a sovereign citizen. Don't. Just don't. So, yeah. All that being said, this has been fun. Go, if you haven't already, check out my previous live stream. You probably have, because frankly, it's my best performing live stream, second or third best performing overall video. So, if you watch me, you've probably seen it. Even if it's the only thing you've seen of mine. And you've probably already seen it, but go watch Team Skeptic's video from yesterday and the one that originated this lawsuit from like a year and a half ago from 2023. Do all the YouTube-y things, like, share, subscribe, bribe your friends and family to do the same. I mentioned I did this on YouTube. I did this on Twitch. I did this on Kick. According to Restream, I've had someone on Twitch most of the time. So if you are that one person on Twitch, thank you for watching on Twitch. That's, it's wonderful. I, watch wherever you want. But if you are that one person watching on Twitch, go and watch, go and subscribe to my YouTube channel. If you guys watch this on YouTube, follow me on Twitch and on Kick and on Facebook and, build all the platforms. And, yeah. So, yeah, I'm a Sovcit aspiration killer. Just, that's me. So, yeah. But that being said, I am hungry. So once you have done all those things, like, share, subscribe, I am out of here. I will see you in the next one, hopefully very soon. So